As we speak today, they are still planning and plotting how to kill your president-elect. Yes.
Petition Akufo Addo naso a efri Ghana ni a Sibio ono so ye professor we hu Chief Justice nyoma bi a waye a Sibio entwaye Ghana mra no ema ye ho kwan se ye hu se Sibio nipa bi a oye dwuma ma aban anase Akufo Addo ato ne nsa afre no ana eyi no se ondi dwuma bi no ye constitution no ema ye ho kwan se wo ye citizen na se ohun se nipa no we bu mra so ana we di dwuma bi a enkoyi a obetuma atwera koma president no na president na ahwehwem President Ishishim na so hu se nipa no edifo a president no ho kwan se obema sa krata na akọ council of the state for no no so dey ama another committee a ye be yi nipa ahodo bi mo matena so apensen mu se nipa no sebio the petitioner no ana nipa no dey asem koto president nim no o wongina so a o se president making sure say sa nipa no so we bu emra so nko ade a se emra na ye kenkan no we bu so a o se sa nipa no ye pam no intana nwumbre petitioner koto Akufo Addo na so efa chief justice ho no me be kenkan ne brofum na madwudwam ni nyina ewo asante kasem ana twi kasem ana kase bi a wa wote ase a me hu se twi kasa na meka ne kese no se ne be ye nyina ebeti ase se ne be ya ochena no nipa bi entumi enkotena radio so TV so enko kansem bi nto John Mahama so enko kansem nto NDC so asem we esiwe Akufo Addo preso me no ka say Nana Dankwa Akufo Addo one na ye president in the next 24 hours obetumi take a decision so sansem we nyina here into we will take the time we have time a 19-page petition. We will take our time to read every single page of the petition. Send your beya Ghana for Ebehuno Kreno. We didn't the cabinet called Bedu Taylor. Show way your friend with all this for extended version. You're the free United States of America. And yeah, they bro, my team no, they are on standby to make sure say no Kreno na one saka. Into more YouTuber. Thank you very much for tuning in. And then my father just texted me. Thank you very much, Kapo, my son. I really appreciate you. My father just texted me. And easy. My father just texted me. He's watching me. Jack. My father texted me. Ubaba texted me already. So it's very important. Team, should I do a little bit of social media slot, or we should go straight and take care of business? We have lots and lots of things to do today. Read. We have lots and lots of readings to do. Be assured, says so many people are ready to listen to petition. No, the womb now Céasë. That's the new journalism we are introducing to Ghana now. So, team, I think we should just go straight and read what is in the petition. After that, it's a time we can do a little bit of social media segment and then end today's show. I'll be doing a lot of reading. My mentor said, to me, I can position this laptop somewhere around here because the reading will be a lot. My mentor, what I can do. I need to move a few things around on this platform. And you bring now, Yentumima Ubia ente the air conase. Yepese Ubia, Yepese Ubia the air co. So, yeah, let me first start with this theme. All right. My team, I'm on green light and say I can go ahead and do the petition. The ready and no be anti-Asie. Into my mushemina from my mene from auntie, ne frere, o papa, ne can say that na se Kevin so obekin kind petition biaba, men could see radio be mobile da dao. Omo kind caption natural, omuya no crane woman no omon canchro. Kevin Taylor said obenya but say akin kind petition no, the woman yinama Ghana for Céasë. Be kind of brofuka crane mejum, be kind of brofuka crane mejum, and then the brofu. Abwache. And then the brofo, and then the baby. Into brofo, ya kind near boomer, mamma bumfu, a brofo, I in a cusia, Irish contumely. By a canny and fine son of Jenya, but send you to your quadim. Into a bear brofo gua, but me kind brofo and machimu tree. Me kind brofo and machimu can cuss him. Send a bear, yama, men of Yapan will be a Céasë, not obin fast being got to John Mahama, so a very, very important. In Tanzania, Becon will be an Musoka cry. I watch it.
Yo! We are best fishermen, solo for no one for my. I watch it. You will for Belgium, Belgium, it was the Belgium, it was two Belgium, why you're yet? Why round what? Why you're yet? Why round what? Why you're yet? Why round what? Why you're yet? To put a why round what? It was for Belgium, it was the Belgium, it was two Belgium, it was the why you're yell? Why round what? 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 Why moto. Yeah, we papa no, what one de moto. Yeah, we papa no, what one de moto. Yeah, we papa no, what one de moto. Wadranga, why yo yeah, wadranga. I watch it. Original.
Hey, Madam for Sofu B, Sofu pa, Sofu Kesia pa Ogana. What text me? Abuache original Sofu, Sofu. Madam for Sofu Penny, Munina Muni, Nasha Cathedral, or come. That's all. The body dear Winna Boom. Nasha Cathedral, or come. What text was here? Abuache original Sofu, Ghana Sofu. Sofu, my mamma, idea Kitabu Sofu Crow. Sofu. Or let me show you what I can say. So everybody this is here. National Cathedral, Okao. I watch any of the start here. Or so for that text me. Sharp, I watch original. So for that, I text me. I was off way. The Ghana. Was that the original? Also, I was off way. Everybody, me see, Ghana off for more. We are stubborn movie. All right, mommy and your guy, you matter now. You quit him now. We did a software here. Software no can I say Cathedral or no just no. Oh, tia watch I text me a watch original. Software. All right, what there? Me come be my son mako body di me nyempo ma me ko benim. All right. Now, software. Hey, me conquer me. Software pa. We nim no. Me say we nim me ehun. Me won now from penny bebre Ghana. From court to Acheampong to there. Software obi anim no Ghana. Me na me catch now. Obi anim no. Are you famous? National Cathedral or count. Or not text me say Abuache original. There me say or the original also. There's a software you. All right, now. Yes, Paul is some catch Paul any 24 no. Also muhuno tips. Wo politics e kuno. Paul. But my friend, you know, they can't bro food to my number of tea kakra. We tea no. Ye, edena about information about ko. Mama me num we no kakra na me di ginema. Sofo no. We tea no. Am se kebitila oba na o di bottle bia ba we no wom. We tea we and oboa. Original abuache. All right, now let's take our business. Mama nimbre. Now, yeah, sorry, and then you bring the breaking news in the say, the Chief Justice, President Akufo Addo petitioned to remove Chief Justice from office. Obi a petition another than Akufo Addo, Professor Kwaku Asare, or guide or professor, or the petitioner command another than Akufo Addo. Now petition no, or see ye need Chief Justice in free. If we say Chief Justice, wabo brabia sabra no etia Ghana sebio yemra ebo sebio Omane ho bra. Eye ye constitutional ene emra ebo eye judiciary eye sebio eye omo a omubuo nsema Chief Justice eda no ewo eye de Ghana no na nsem na eye abranti Acheampong Akufo Addo say Ghana man ho kwan ena Ghana constitution man ho kwan say se yetu yensa anase yeyi obi president tu obi se ondi dwuma bi ema Ghana na nipa no wa misconduct no ho anase dwuma de na wedi no wan di no kwan a also di so no obumra so a Ghana for as citizens, you're right to see a Bakacha president say, Nipa we die, Sebio, Nyoma weni na waya, a chile say a Juma Odoman and we bugana mraso ebuidim tia. Emma, Embrana webusinti, a yasa nipa betina a office. Samukaya, time and another Danko Akufo Addo eba office in 2017. Anche, ena Emrantibi, Echro Krata Koma Akufo Addo say, Madam Charlotte say, or ye the EC boss no. Sebio, Ghana Emranoma, Ghana for. To me say omontra krata embra president no mo fama to nanim say sebio nipa your friend Madam Charlotte say no sebio time na oye EC boss no nyoma bi wo ho a oye ya amfa kwan mu na etiamra entina na do Danko Akufo Addo enhwe saa nyoma no ngina so na onfa saa nsem no enkyere Council of State no the check Council of State wi a ombie committee na committee no agitum say Charlotte say an conducting hu ya o se twena so. Sa emra no ena nanado Danko Akufo Addo edi so mampanyini a odi yi eye Charlotte say free electoral commission ene obi atchro eye petition de akwa eye Nana Addo Akufo Addo odan ho the same president na krata na ochro no ochro de epo ana points ana inginaso enyina ahye mu kire Akufo Addo say wenti ena ende me ka kire wo say eye Madam Tokonu no pamono as the Chief Justice of Ghana. Now mama yanko kan krata no de ewom say de baya ochena kwase bi embetena wuntumi TV Jimmy Phobia and Hokanka bi mbetena Peace FM. Sebio eye political go to be embetena baby embetum futuro ngumani. We eye dwumade a ye di e de ayeden ama Ghana fo ehu nokure a ye de kekere man. Now, krata no mebie so ha if we say edos ye eye 19 pages. So I will take my time and read the 19 pages to eye Ghana for. Now krata no offer eye krata fan e de nim eye the first page. Hey, and there. Obianya ready na yebedwum 19 pages ye pon ane apon. Now ohwe eye krata no so a omatro 17 December 2024. In fact, this is a public document. Okwa abontene a ewo ho obia obetumi akan. Eye 17 December 2024. Now Mr. President office no omo receive eye sa krata we eye Ghana time 4:33 p.m. Reception no nipa na oje krata no ne number edaso 0244194142 ono ena sebio or reception ho a krata no kosi ni so ni dindi Joseph Kobena Wuba ono ena je krata no sign ye ka say yaje ye de akoma president inti sia na me no ka say sa petition no eda na Nana Addo Akufo Addo table so na krata na nkasa o kan a de wo mu nie brofo ni nie miwia na medwudwam nipa sebio o petition Nana Addo Akufo Addo ana MPP aban we no nipa ye frɛ no I'm in picture nto so ye frɛ no Mr. Anasa Professor Stephen Kwaku Asare onie oye Ghana ni mapa oye professor oye Ghana ni osa kira de America ote Ghana sati America watro krata we oye Ghana ni mbra man ho kwan se ono so ede na no asem ene ngina so a owo ede betu Akufo Addo nim se ontu ho anamo nti eye abrantie ana papa yi a ye frɛ no Professor Stephen Kwaku Asare ono ene chro krata we ede koma Nana Addo Akufo Addo o se yendi ho dwuma efri se na eye Chief Justice Madam Tokonu abobra bi a bra no eni se otena office se Chief Justice of the Republic of Ghana. Now mama menko eye krata dim na medwum ahanko na obehu sa de we uhu bi obebi abiem Oma maka nyina oma read caption akire no motwa wotro eni ntina mse nya abotre me na wo kan brofo na madwudwam. All right team. And somebody is drawing my attention to something. The petition was written on the 17th, but the person who received the petition received it on the 16th. So the petition was received before it was written. But we will deal with that matter. Let's look at what is in the petition. The petition was written on the 17th of December 2024. But Nipana or receive petition or Jubilee House no date is 16th of December 2024. So it means somebody is being diabolic in the Jubilee House. From what we are seeing on the petition, that means the petition was received before it was written. But we will get to that part. We will break it down. Thank you very much, team. Now, petition again, or say 17 December 2024. His Excellency, the President of the Republic of Ghana, Jubilee House, Accra. Dear Mr. President, petition for the removal of the Honorable Chief Justice of the Republic of Ghana, Her Ladyship Gertrude Saki Tokonu, CJ, pursuant to the provisions of Article 146 of the 1992 Constitution of the Republic of Ghana. Assembly no anase caption no anani tipo no kire say or say sa krata or trabre krata ogina Ghana the constitution so de akire Nana Addo Akufo Addo Ghana nyina say mbra no hye ne keten say sebio the constitution aka no sa petition anase asem obetu nanim no ogina Ghana constitution so na ode kire sa krata na bre Akufo Addo enti enye say ne pe wahwe constitution no wahwe mmra no na ogina so e de akiro krata no e de ama de Ghana say Nana Addo Akufo Addo ontu ho anamon. Sorry guys, I beg you, don't distract me. I'm not talking to my team. People calling my phone. introduction a petition page 1 or say I, Professor Stephen Kwaku Asare, a citizen of the Republic of Ghana, respectfully submit this petition to Your Excellency, the President of the Republic of Ghana, seeking the removal of Her Ladyship, Gertrude Sakitokonu, the Chief Justice of the Republic of Ghana. On grounds of, or say, or no, your friend, no, Stephen Kwaku Asare, or ye Ghana ni mapano, or Trakrata way, Eddie Brennan, Adom Kwaku Addo say, Chief Justice, Chief Justice, Madam Tokonuno, was say, or Pamono, na injinaswa o jinasuni. Or say 1, stated misbehavior and incompetence. Or say nyama mienu na o jinaso edi akache na Adom Kwaku Addo say was say Chief Justice no ya pamono or pamono ni menime ya na nyama mienu no say Chief Justice no sebio eba eyedien eba bibia ye frɛ no eyedien ni amoho nsɛm or ni misbehavior omumra omunipa sebio oyede opɛ ɛna yɛka sɛ incompetence udi dwuma ma na ontumi ndi dwuma no sebio nyansa yɛdidi dwuma ɛma yɛhu sɛ wedie yɛde nyansa pɔ ɛna yɛdi dwuma ɛma dwuma egyina ne naso no ɔsɛ yɛka bibi te sɛ incompetence sebio oni saa nyansa kadeɛ na yɛtumi di dwuma ɛma dwuma esipi incompetence and also they stated misbehavior or say ɔwɔ ahomasoɔ ɛne ne su ɛne ne ban bi a sebio ɔde ibu mmara so. Inti nyoma mienu ena ogina so edi akache na Adom Kwaku Addo say Ampong Chief Justice no na answer na ostalo dinkaka say constitution ne ma ne ho kwan say de ye ne na no te say Charlotte say time no ye betumi so aye ne ya into o state ye article a ogina so edi atro krata we edi ama na Adom Kwaku Addo ene ye article 146 of the 1992 constitution into owo ho kwan say obetro krata we ama Kwaku Addo. Now point 2 or say the legal basis of my petition is Article 1461 of the 1992 Constitution of the Republic of Ghana. For the avoidance of doubt, my petition focuses on stated misbehavior and incompetence related to the Chief Justice's administrative functions as head of the judiciary responsible for its supervision and administration under Article 1254 of the Constitution. Or say, adikudientia or jina so the ojina so edia kache na Adom Kwaku Addo say Ampong Chief Justice Madam Tokonuno say Ghana Constitution no baby say oye Chief Justice ana oye nipa sebio constitution no ama ho kwan say di dwuma bi na wendi a constitution aso esa ewo emra bi a ekire say wendi odwuma ye se ne etia o se egina sa constitution aso esa yi uto akonwa nti eno na ogina so e de aka che Akufo Addo say Ampong osono ma me sorry Ampong Madam Tokonu a oye Chief Justice. Also, my petition does not arise from the Chief Justice's exercise of her judicial functions. Accordingly, the petition does not challenge any decisions, orders, or directive issued by the Chief Justice in the performance of her duties as a Justice of the Supreme Court, including those made to enforce judgments, decrees, or others in cases she has adjudicated. I fully understand, respect, and value the importance of decisional independence. Or see, Mr. President, krata ochramao no sebio emfa asama Chief Justice atena so edi or say ene de emfa ho or say obu Ghana mra obu eye edwuma a omedi no court eye Supreme Court any court aka or say sa the petition or three enye case bi a Chief Justice any Supreme Court judges bi tena so and say Chief Justice na tena so na oka ho asem eno de sebio ohuni se eye edwuma wo so di na eye petition a ochro no eye nyoma mienu wodinka ase ana aka ho asem ene na ogina so intimema Mr. President wa adwene nya wo say atemkuruwa ana say judgment bi a Chief Justice ajage wa asem bi so ankoye ana say bi a webu asem bi asebio na eni ne kwan so say enye anu nti ena ochro say yenyi Chief Justice emfree de the position as the Chief Justice of Ghana. Okon enim no say and point 4 or say it is my understanding that upon the receipt of this petition, Your Excellency shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices, Supreme Court, one of whom shall appoint as chairman, and 3 other persons who are not members of the Council of State, nor members of Parliament, nor lawyers. See Article 146 of the Constitution. Also, petition Mr. President, you know mumrano. So petition we become on sa. Dear also we because Ghana mrano echre say the petition say betu nsema ye wo emra bi a wo say wudi so sebio eye article 1466 ene na kire de wo say wo ye into on saka eye petition we no emra no eda ho Inti di mmara no so na yɛnhwɛ sɛnea asɛm wei no ɛbɛkɔ. Na ɔka no ɔse mmara no ne sɛ sɛ wo nsaka petition a one deɛ ɔsɛ woyɛ no sɛ first of all ɛwɔ sɛ woyɛ dɛn wofa ɛyɛ judgefoɔ mmienu a sɛbio ɔmo Supreme Court sisi a wobɛte committee ana ɛyɛ nipakuo bi a ɔmo no ɔmbɛhwehwɛ asɛm wei mu no. Na constitution no kyerɛ ɛwɔ article 46:6 sɛ ɛwɔ sɛ wofa ɛyɛ 2 Supreme Court judges ɛwɔ saa committee no so no. Now ɛna ɔse 2 justices 2 Supreme Court justices includes those made to enforce judgment, decrees or orders in case. No, let me go here. 2 Supreme Court judges, one whom you shall appoint as a chairman. Or say, Mr. President, Mbraniche say, or say, Supreme Court, Obeti Committee, Momash Assembly, also we judges, many free Supreme Court, or Sabako and a chairman of Edian, Sa Committee, no, and 3 other persons who are not members of the Council of State. Into also Council of State in one, so Mbraniche say, Council of State in Article 146, nature say, and this we nipa bia every Council of State, or say, Ukoi nipa. Mensa free Abontinia, Omuni Council of State in Mukra, into 2 judges from the Supreme Court, Baku and also a chairman of the committee, and also Osaka for Nipa Mensa, Omon Council of State for one home, and also a yadiang Omonka Nipa Ukofa Nipa Mensa Bekamwa, Sani Panisa Omoka Parliament, and Nisa Sebio Omuye lawyers, and Nisa Sebio Omuye Council of State members, I will say only Pebi independent. They are not supposed to be Council of State members. They are not supposed to be lawyers. They are not supposed to be they are not supposed to be members of Parliament. You just have to take 2 Supreme Court judges, make one the chairman, and go out there and pick 2 or 3 people who are independent-minded to be part of that committee to sit on the Chief Justice Assembly. So, now, it is my further understanding that the committee shall inquire into the petition and recommend to you whether the Chief Justice ought to be removed from office on the grounds maintained in this petition. I affirm my understanding that all proceedings herein shall be held in camera, and the Chief Justice is entitled to be heard in her defense by herself or by a lawyer or other expert of her choice. Or say, ebe kono say senya ye kɔ enim no e wo sɛ ɛyɛ deɛ asɛm we no wo make sure sɛ wobɛtumi ɛde ɛyɛ petition we ɛbɛma committee na ɛbɛyɛ 2 judges from the Supreme Court, baako bɛyɛ chairman na nipa bɛyɛ miɛnsa a ɔmo firi abɔnten ɔmo firi parliament ɛmfiri ɔmo nyɛ lawyers ɔmo nyɛ state council of state members saa nipa bɛyɛ 9 a na enum no ɛwɔ sɛ the petition we ɛde ma ɔmo na ɔsi Mr. President ɛbɛyɛ fɛ sɛ asɛm we no yɛbɛ nyina yɛbɛhwɛ no TV so na Ghana ni bia ehu sɛ yɛnka asɛm ɛnto Chief Justice so nti nka ɛbɛyɛ sɛ nka Mr. President sɛ asɛm ne mu bɛda hɔ korɔgye ne deɛ anka Chief Justice na ankasa ɔbɛpene a ɔsɛ nka asɛm we yɛn nyina yɛtena camera mu na Ghana fo nyina hwɛ bi na yɛtoto nano na yɛnhu sɛ ɛyɛ petition we ngyinaso wɔ mu anasɛ ngyinaso nim ndwidwamu no ɛna ɔkyerɛkyerɛ mu no. Now point 6. It is therefore my understanding that Your Excellency, the President of the Republic of Ghana, Your Excellency, shall act in accordance with the recommendations of the committee. That is C Article 1469 to 1466 to 9. Or say, Mr. President, says our petition we no sebio ube make sure say Eya committee no ene wankasa mo di mraso because Ghana mrano dawa sebio ehye wo president ene sa committee ni say omo be ye den omo be di asem we echi emiako edi asem no krogin sene tie. Now afei na obekye the background the ogina so e di atro sa petition we the ogina so ensem a ogina so nti o se Chief Justice Madam Tokunu enise oye Chief Justice of Ghana eno na yesi amebeki dwem akyerɛw nti obi ase papa ya tro letter ko Akufo Addo se ompam Chief Justice edien pa na Chief Justice aye edien nginaso na ogina so aka kyerɛ Akufo Addo se onti committee na yempam Chief Justice because we di abro wayɛ nyoma bi a sebio ye constitution anase mbra ebo Ghana ho ban esabo judiciary no ho ban no we tietia so anase we mu mbra no. Now, I feel over the original so the actual petition we and a friend of background. Now, background. Also, request for the appointment of 5 justices of appeal to the Supreme Court. Or say, Adé Bakwa Chief Justice here na ehu etiamra ewo se gina so ede pamono emane ko tena fiema sebi oni pe bi be na nan ne say eye Madam Tokonu a oye Chief Justice of Ghana oye say onu ankasa de ne pe ebe appointi eye judge fo num bra eye Ghana mra no etia into say ingina so ne ba ko edi nkan ne say eye Madam Tokonu oye Chief Justice no o de onu ane pe appointee now person appointed judge for num eco Supreme Court. Now in by a letter dated 30th May 2024, the Honorable Chief Justice of the Republic of Ghana formally wrote to Your Excellency, specifically requesting the appointment of the following 5 judges of the Court of Appeal to the Supreme Court of Ghana. Or say a 30th May. May da 30th May 2024 afiwe mu no Madam Tokonu chro letter bre wo na Addo Akufo Addo ena letter na o chro bre wo no or the judge for enum omo ye appeals court judges for enum the bre wo say sankofo no make sure say obema sankofo no abewura Supreme Court na judge for enum Madam Tokonu petition and asem o kan no kwesi Kwaku aza asem o kan say 30th May this year no Madam Tokonu should actual secret letter the come Akufo Addo say oh judge for numu we dey ye fast the for Bobra Supreme Court itiamra article 146 to 9 no 1466 to 9 no itia o say sa judge for 9 no mo ye appeals court judges yi omunie 81 petitioner and I say Kwaku aza and Mr. Kwaku aza no wa kire wabo dates into a very important date womb. Now, judge for 9 anomaly appeals court judge no omunie. His Lordship Justice Edward Amwakwa Santi J.A. Her Ladyship Justice Angelina Mensa Homia. His Lordship Justice Eric Bafo. Her Ladyship Justice Syria Pamela C.A. Kranting J.A. Her Ladyship Justice Efia Asariboche J.A. Also, sa judge for a numwe secretly. Madam Tokonu extra letter come Akufo Addo say on make sure say obe present your mama parliament me de omode abahin Supreme Court Ghana mrano eyade tia Chief Justice enkwahye kukuo mu ntro letter nkoma president say president nipa numwe for mobra Supreme Court no into say we bi ni nyoma ogina so now time a Chief Justice extra sa krata ne koma President Akufo Addo say onfo koti kwan bi so na onfo sa judge for enum wei embra Supreme Court emma no ono ana dwene mu no ochro note bi to so nyoma bi a ochro ka ho a kire se e wo se Akufo Addo emma sa judge for wei kwan se bi ono na pese omoba Supreme Court commenter Chief Justice ochro fa judge for bi e wo sa letter no ni regarding his Lordship Edward Amwakwa Sante judge ba kwa na efre no Edward Amwakwa Sante no Chief Justice Tokonu cho letter ne dey say no ochro fa no ho o say Justice Asante's term of office at the ECOWAS court ended on 31st July 2022. He was requested to remain at post on account of the withdrawal of Mali, Guinea, and Burkina Faso from the community. His current tenure is expected to end in 2026 or earlier when he is expected to return to Ghana's judiciary. Now, letter no Chief Justice Achron say His Lordship has provided. The letter goes on to say that, and Osachro say, His Lordship has provided excellent leadership as President of the ECOWAS Court and will undoubtedly be an invaluable asset on the Supreme Court of Ghana. Chief Justice Tro Sakratano secret letter come Akufo Addo say, judge your friend Edward Amwakwa Santino. At the Kudientia on the Chief Justice instructed on Akufo Addo come with bom. See and Supreme Court and say, Sir Judge no or ECOWAS Court. Na Madam Tokonu say oh sa judge ne de miamini pano no wa ya de say wa board ho modern say mini pa say oba na oba Ghana Supreme Court oba be di dwuma aboaye ene na wo letter nim into say san nyoma we a Chief Justice troye e wo letter nim no ene kire say Chief Justice na boapayo ni da ho ena all selected the Black Star players through the president to come to the Supreme Court. Or say regarding His Lordship Justice Eric Bafo and their Ladyship Angelina Mensa Homea, Syria Pamela Kranting, and Ifua Saribochi. However, Her Ladyship, the Chief Justice, wrote that day. Or see, judges 4 na Canada, Mukai Jacheba 4. Jacheba 4 no catch them or the warrant at Thomas forever and ever. Mukai. Aha. Or then your friend Jacheba 4. Yaniko appeals court. Or no na Okanwa Chief Justice said by force. Or person of Kotoka Edeniko Supreme Court. Inti Jacheba 4 na oka eye judge 4 enum ho. First one they know ECOWAS court judge. Or can want some throw the reason to Akufo Addo Fanembra Supreme Court. Now 4 na kano letter na eye Madam Tokonu secretly Echekome Akufo Addo no. This is what she said about the 4 judges left. Or say all these 4 judges, and I quote, are currently working as judges of the Court of Appeal. Their work has been distinguished by outstanding services, courage, and competence. End of quote. The grave nature of the Chief Justice's role in requesting the appointment of the said justices to the Supreme Court became evident when subsequently social media published another letter dated 7 February 2024 from the Chief Justice to Your Excellency. Inti Judge 4 na kan Chief Justice letter no sa my Akufo say, oh, we mu de. Wa wunim yankofo oma bom ho modin yie. Inti hwem Justice Cheba 4 on the warrant to Kevin Taylor so no. Inti san nkofo no maka no make sure so mu nyina letter we mu no mu din hyem. Inti a protocol list. And a Chief Justice Kotonu a o se oye de oye neutral no okuta ni protocol lister or de koma Akufo Addo say for Mobra Supreme Court. Mr. P. Yeah, okay, so that's the letter, right? Okay, my team listen for letter before we move forward. This is the letter now. The petitioner is talking about in the petition. My letter na yentwaso sene beya obi abehu sasema ye kano enye atro na yedi ediato Chief Justice Tokonuso. So this is the letter. Letter when an Chief Justice etro koma Akufo Addo a petitioner Kwaku asari chechirimu ache Akufo Addo say we etiamra. It will letter now, His Excellency Nana Addo Akufo Addo. Osha top one, Honorable Chief Justice. Date show 30th May 2024. Meaning the petitioner Kwaku asare no wa both date date no e letter no wo a say Chief Justice Madam Tokonu saa no. Since letter we ba abonten Madam Tokonu ba abonten kaka say enyo no the secret letter we are or the protocol list come Akufo Addo say omo Supreme Court. This is the letter. Osha, His Excellency Nana Addo Akufo Addo, President of the Republic of Ghana, blah, 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 blah. Your Excellency, proposal for appointment of 5 judges to the Supreme Court. Chief Justice natural letter we come Akufo Addo. It was intercepted. It was published on social media. The basis in tia or Chief Justice. Na odi protocol list ko akope nipa bi obetuma ye dwuma bi ama no e Supreme Court e na ye che no. You can see the Chief Justice, the protocol list in the secret letter he wrote to Addo Nana Addo Akufo Addo. I write to respectfully request that the following judges be appointed to the Supreme Court. This was a request. The Chief Justice, Catcher President said, Momombra Supreme Court. This is dangerous. You have a protocol list in the Supreme Court and to become a Supreme Court judge. But the Chief Justice, Madam Tokonu, did that. And in a petition now, what shall letter come Akufo Addo say? I was some many a pamano because when you do this, you have committed a crime. And the Constitution states it clearly. Article 1466, Article 1466 to 9. No, it is clearly say you cannot use that your position to influence positions to the Supreme Court. Clearly, no, our reason and basis in tia what shall letter come Akufo Addo say. Madam Tokonu, letter nini, that's the evidence. Now, mommy and back to the petition. Send a Ghana for ebe to me, and who said the ekosono any. Now, petition uko edima. Or see, even on the 7th of February 2024, yeah. 7th February 2024, yeah. It's captioned, brief on the need for the minimum number of 20 judges on Ghana's Supreme Court bench. In the said letter, the Chief Justice stated that, almost say, 7th February 2024, yeah, the Chief Justice, Madam Tokonu, sat another letter. A letter now, such a Akufo Addo, no, or stating reasons in tia, and what say, or no, and making sure, say, judges almost Supreme Court, no, you move on 20. It's the reason here. Now, ne protocol list to say Akufo Addo mu nyina beba ne say na ono no opese o move Ghana Supreme Court judges no etu the 20 opese o mu ye 20. America kakrake ye Supreme Court judges ye 9. And so Madam Tokonu any Akufo Addo atro mo letter Emma omo ye plan say e wo say ye den ye move ye Supreme Court no judges no numbers no ekọ den ekọ 20 now tie letter na eye Madam Tokonu tro come Akufo Addo no on the 7th of February 2024 no Mr. S. Okay, so letter no so me team ne dia ba I will show you that letter on February 7th I will tro come eye den eye Akufo Addo no I will show you the letter before I read letter ni. Thank you Mr. P, thank you Mr. S, thank you for bringing in this letter. Now, me team is 7 letter. This is the letter Otrono on the 7th of February. Or Sakache Akufo Addo. First letter the 30th May. Or catch 2022 no. Odinka Kache Akufo Addo say on for 5 judges we mra. And at 2024 7th February no. Or some reasons in there. Also or person or move judges no to 20. Now this is the letter Otroye on the 7th of February 2024. Na or insist to say or person or movie air judges no 20 where ye Madam Tokonu ne terminal report na me read actual no. Honorable Chief Justice of the Republic of Ghana 7th February 2024 His Excellency the President of the Republic of Ghana Office of the President Jubilee House into which letter na Madam Tokonu Chokome Akufo Addo na brief on the need for a minimum number of 20 judges on Ghana's Supreme Court bench. Into Otro Kome Akufo Addo say after all the protocol list of 5 commanders on former Supreme Court no appeals court judges no or Saba 2024 be man reasons in tra or person also expanded judges almost Supreme Court to 20. Now this is the letter. I'll say respectfully I write in reference to our previous discussion on the Chief Justice's proposal for an increase in the number of justices of the Supreme Court of Ghana. Kindly find attached a paper justifying the need for the request. Thank you very much. Madam Tokonu, the Dean Céasë, no, into Chief Justice Nankasa Chokome Akufo Addo say, the reason there's a need for a Ghana judges now Supreme Court no, or no, after bringing 5 protocol lists no, from appeals court no, or sa insist say or say my judges no could do 20. Yanko enim, yanko kind petition in the womb. Into petitioner no, he was telling you evidence ewoho enye bosremuka or show evidence any embra Chief Justice Tokonu ebuso. Now, no point 13. Or say the above quotation suggests that there has been a previous discussion on the subject between Chief Justice and the President. It is already letter na quotation or any caption it say Chief Justice ne Akufo Addo didn't plan. Now they wanted to make it official. Into petition and say so already letter ni here only say President Akufo Addo ne Madam Tokonu Céasë and I'm planning say the protocol list of 5 Madam Tokonu de bebrelo na wa pass omo de omo Supreme Court owia na wasa de krata ba injina so a opese obie judges ni more emom ye 20 e Supreme Court until they had planned it. And a petition and say so already documentations na follow ni nyina e kire say Akufo Addo ne Madam Tokonu no omo tenas na omo plan say omo the protocol list be Supreme Court omo wi na omo say bie judges nim to 20. Now petition and call him no say point 14 of concern to your petitioner is the fact that both letters, one proposing an increase in the minimum number of justices on the Supreme Court of Ghana and other requesting 5 specific judges to be appointed to the Supreme Court, were written on the letterhead of the Chief Justice and clearly expressed itself as the Chief Justice's personal request on the matter. The letter did not refer to any consultation or involvement of the Judicial Council, of which the Chief Justice is a member and within whose constitutional mandate it lies to deal with matters relating to the appointment of justices of the Supreme Court. Or see, petitioner said, "Usha letter Mirina Chief Justice Etro Command and Anado Danko Akufo Addo." Let me put it on the screen. Senebeya obeti asie. Usha these 2 letters are Madam Tokonu Etro Command and Anado Danko Akufo Addo na. You can see clearly say the letters were coming from the office of the Chief Justice. Now, the money you say you be a friend of the Judicial Council. Judicial Council no embrasha omo say ye pese ye appoint a judge phobia at the Supreme Court. E was say Judicial Council no trase. Na omo ye pensemu ehwe mu mra edwendwene ho eti ase say we die a good decision and I say a good decision. Judge we qualify and I so qualify. Petition and a petition no Kwaku Azakache Akufo Addo say. Uje 2 letters na Madam Tokonu Chobra first one say Sebio or the 5 protocol list or Nwankasa hand-picked judges. And the second one or Troya or say the reason why into a person will be a judges now was Supreme Court to 20 no. Osha letter ni mienua letterhead if you on Nwankasa office. There is nowhere in the letter as cited says she consulted the General Legal Counsel. And I say she consulted what we call where's the name? The Judicial Council. There's nothing on this letter, sir. Say the Chief Justice consulted the Judicial Council. It means to say that decision was solely taken by the Chief Justice herself, which is against Imra. So the Chief Justice is now Mugabe. The Chief Justice is now an authoritarian. The Chief Justice is now running the Supreme Court or the judicial service and the judicial system as her own property because she's sending letters to the Jubilee House with her letterhead. And in the letter, she did not state anywhere that she had consulted the Judicial Council on this matter. So clearly, the Chief Justice has breached the law. She is basically being an autocratic leader. She is misbehaving. That's amount to misbehavior and it's countermount to the sacking of the Chief Justice. This is the petitioner's reason. Until Akufo Addo or say Opam Madam Tokonu, and he's not just stating the things. He's using facts. He's using articles. He's using the Constitution and making the president understand to say, Emrana Bogana Homane Chile say, or say Chief Justice take a steps way. So when taking steps way, and nobody is supposed to allow her to be as to be there as the Chief Justice of Ghana. Now, Yanko point 15. Point 15 in the petition. Team, are we good? Thank you, team. Thank you. You know, say we do live production. When I need something, the team will pull it. So that's how it works. Now, when you go to point 15 in the petitioner page 3 out of 19. Hey, Asamoah. Point 15 say, your petitioner is further concerned by the reference to an earlier discussion between the Chief Justice and Your Excellency the President on the proposal to increase the number of justices on the Supreme Court. Your petitioner also notes that the question of minimum number of justices on the Supreme Court is settled by Article 1281 of the Constitution, which provides that the Supreme Court, and I quote, the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court, end of quote. Or C, petitioner say, say Nana Addo Akufo Addo wunim se emrada ho a ekire say ye Supreme Court na nka say de I say a Chief Justice any 9 judges kan ho ma ne 10 and was say omo ho at the same time inti day na Chief Justice Madam Tokonu a onim Ghana mra nyina no etumi tro letter bra o ka kire say opese or expand adia constitution ehye ketin. These are entrenched laws. Constitution ehye say I was say a Supreme Court no at every given time or say judges 10 ho Chief Justice plus 9 judges. Now, you, the president, who is a lawyer, a so-called lawyer, who knows the law, so Chief Justice actually let us say, Edia bro, say, even though she knows the Constitution states this emphatically that you cannot exceed 10. No? Why did you, at the end of the day, not raise any concern into the petitioner now or letter for say a shocking? The president does not respect the Constitution and the Chief Justice does not respect the Constitution because it has been stated in the Constitution. So Article 1281 or say at a given time no you have 10 judges at the Supreme Court. Chief Justice plus 9. Inter Chief Justice to let a president to say, Mr. President, me 20. It means somebody is taking advantage of the Constitution. Somebody is abusing their office. It's either you, the president, or the Chief Justice. Now, the Chief Justice has to go because the petition is directed at the Chief Justice. Now, let's go to point 16. Ghana for Céasë. This is how it's going to be done from today. Sani ebeno ya de no kure na bebo Ghana ho ban. Sani be ya obi ntumi nko twist nsembia enkoka nsembia ntu obi aso. 2016. The plain meaning of Article 1281 is that the minimum number of justices for the Supreme Court is 10. Thus, an amendment of the Constitution is the lawful way to change the minimum, not by a private discussion or communication between the Chief Justice and the President. It is Parliament that has the power to amend the Constitution, Article 289 of the 1992 Constitution. In the petition, Mr. Akufo Addo, Ghana Mrana Chre says sa part of the constitution, article 1281 of the constitution, I say it was say at any time Ubiano, yet Supreme Court no judges all include the Chief Justice yet 10 no. It is only amendment, amendment, sa part of the constitution 128.1 no. It was say ye sacrim ye and saka any of an amendment, ye sasha ni biem say a bed done kakra. So far, amendment biambaye. And at the end of the day, say some run and Sabeka, I can say judges 10 or more Supreme Court, I'll say the 20 year. I will see this a day, and Mrano echo do parliament. Not parliament at deliberate near to Swaba and Sunny Agya to say, you per se you expanded the number of judges at the Supreme Court. But Social Lieutenant Chief Justice Akufo Addo, it is looking like they have ignored the procedure and process. And it is beginning to look like a personal vendetta, a personal agenda. A Chief Justice Akufo Addo are conniving behind the scenes to slaughter the Constitution of the Republic of Ghana. Into the petition, I say, what he is seeing, and he say, you, the President and the Chief Justice, you have connived because from the correspondence, from the letter, no, the Chief Justice is basically flouting the laws. She's going against the Constitution of the Republic. Chief Justice now, or the Supreme Court, or interpreting Constitution, no, she is basically doing what? Fucking the Constitution. She is basically murdering the Constitution. Or Danny who say I am interpreting it. Or Sadan who say then she is murdering it. And then a petitioner, Asareka say, Nana Danko Akufo Addo, what we are seeing, no, it is looking like Chief Justice no or no alpha Ghana judiciary say more personal property. Now, point 17. Further, your petitioner has reliable information that a meeting of the Judicial Council held on 14 June 2024, the Chief Justice expressed her desire to increase the number of Supreme Court justices, whereupon the Council advised her ladyship to pursue broader consultation with other institutions on the matter, especially the Parliament of the Republic of Ghana. Or say, Mr. President, petitioner said, Mr. President, the Chief Justice at a meeting a course between the Chief Justice and the Judicial Council no, on the 14th of June 2024 no, was stated our date. Chief Justice echo meeting as no crazy say, oh, me perceive me increase the number of people on the Supreme Court bench. And the Judicial Council focus the Chief Justice. Sa same way, and yet easy sa because constitutional a barrier a jinaso. In Tinkebeya and Chief Justice, ye ending kind and consult Ghana for yina. Yen consult parliament. Ni any parliament in Tenase pense mu. Send ye beya ye bet me to sa na more way and so Chief Justice NTA. I'll see meeting also on the 14th of June 2024. Meaning at that meeting, the Judicial Council told her that if she solely take that decision, it is against the law. So she knew that the intent was to commit a crime. From what the petitioner is saying, Chief Justice had an advice from the Judicial Council telling her that do not even think about it. But the Chief Justice, upon all the advice she was given, in this point, we will say the legal advisors of the Chief Justice was the Judicial Council, but she ignored their legal advice and decided to take her own decision. And no enema who said she flouted the law and became an autocrat and decided to subdue the Constitution to benefit herself by selecting 5 individuals she thinks are her boys and girls that can work with her. And also, her herself decided to expand the number of judges on the Supreme Court bench. It is dangerous. It means the Chief Justice has stabbed the Constitution in the heart. And as a person, personally, she wants to run the Supreme Court like her own business. On the 14th of June, Judicial Council for catch and say, hey, Adya, we're dangerous. We need broader consultation. And even after the broader consultation, I was say you call parliament, any parliament, and some person will be tackle president. But Chief Justice told them they should go fuck themselves. She knows what she's doing. And in a petition, and say, let us a sound to say when the president and the Chief Justice wedding come with Chile and a more plan. Petition point 18. Point 18. The petitioner, the Ochema, the Kudientia was a Chief Justice, a Pamano Enie. Besides, what again? Which one is this? Okay, so my team is a member a constitution in Chiramo. Article na the petitioner Edeka Hono. the Supreme Court, how many judges is supposed to have at a given time. We need to make sure the facts are stated on the show. Now, Kotoka Ghana, chapter 11, the judiciary. This is what it says about the number of judges are also at the Supreme Court. And so, the petitioner has a case. Now, 128.1 not petitioner estate the petition no or say constitution say the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme Court. In the Constitution, it makes it clear, and Chief Justice Kotonu, who is supposed to interpret the Constitution, knows this. Even at a meeting where the Judicial Council advised her that do not do this without broader consultation and also consulting Parliament, she still flouted the law, went against the law, and decided to go behind the scenes to work this thing out with Akufo Addo to bring their shortlisted judges to the Supreme Court. The petitioner is telling you, say, Emra ewoho a Chief Justice abokro no enie inti yengina so ne pamono. Let's go back to the Constitution. Thank you very much, team. Now let's go back to the Constitution. Hey, let's go back to the petition. Petition point 18, page 3 out of 19. Hey, Debbie. At the said council meeting, the Chief Justice did not disclose the fact that her desire to increase the number of Supreme Court judges had been the subject of a previous discussion and communication with His Excellency. This fact became evident only after a letter dated 7 February 2024 from the Chief Justice to Your Excellency appeared on social media. It follows from these facts that the Council had no knowledge of her involvement in the attempt to increase the minimum number of justices beyond the constitutional specified number. The petitioner say, even meeting the course, na Judicial Council for nimu po say, time I muti meeting, I say, Céasë, na Chief Justice Krampo din catch letter come president. Until say letter no Krampo ba abontene. It's Chief Justice no otutu anoma, and the court Judicial Council for say, otutu anoma no wie no say anoma be nie. Na oyo mo krokro de John. Abraham also consult you first, we didn't get taking the decision away and son of Obe to Anoma watch say, oh, Anoma we bola bed and I say here because she had already connived with the president behind the scenes. Because I will check the date of the letters now. Those days which clearly say the Chief Justice had already written to the president before even meeting the Judicial Council in June 14, 2024. Meaning on February 2nd, now or trucks and a letter no, any a year the previous one in 2022 no. That means that before we got to June, no, not Chief Justice didn't catch a letter come Akufo Addo. And send out to Anoma who catch the Judicial Council say, oh, me person can expanded the judges. Chief Justice had already broken the law. She's already broken the law. We boom run so that and what Oba make sure say Judicial Council at the end of the day will be part of the law she has broken. Because you see, she needed an accomplice. The Chief Justice knew, because I know she knows the law. That is why she's at the Supreme Court. She needed an accomplice to help her in law. And I say in investigation, FBB, alibi. The Chief Justice needed an alibi. She needed somebody that their words will sync with her word to protect her later when she's caught. So she used the Judicial Council as an alibi. Senebaya same way back. Chief Justice Becker said, oh, I was at the meeting, so I already told them. But the letters and the date on the letters actually exposed the Chief Justice. Said she actually took that decision before meeting the Judicial Council. So she had already committed a crime. But it was an afterthought that, okay, my committed crime anyway. Let me now implicate the Judicial Council. Senebeya, I cannot be sidelined or isolated and punished. So that meeting, she went and basically threw in that suggestion. She had already taken a decision and the evidence is in the letter. Now, page 19. The article 128 clearly states the Chief Justice must go. And this is the petition to the read. Number 20. The Constitution requires the President to act on the advice of the Council in consultation with the Council of State when nominating Supreme Court judges for parliamentary approval. The Chief Justice's elaborate scheme of requesting the President to appoint specific judges and later presenting these names for the Council approval subverts the constitutional scheme and converts both the Council and the President into rubber stamping her preferred judges. As it turned out, the scheme was fortuitously undone by the Council's concern about the timing of the nomination. Now, when the petition is being considered at any stage, members of the Judicial Council will be subpoenaed to testify on the matter. Petitioner say be judges for and I say be judges at Supreme Court. The Constitution requires the President to act on the advice of the Council. I was a President in every Council of State because me person the judges for be adding Echo Supreme Court. Na mo na mo Council of State. Mombra na mo ne member fa ho adwene. Nipa num mo mo saying, mo adwene mo saying, ansa na owia na sa eye de sa eye nominees na Supreme President be or the accord Parliament. Or the court parliament not parliament for also avert or vert we are answer approve and send a job to some Supreme Court. But this is the case whereby the Chief Justice, at the end of the day, she basically decided to put together a plan that will cut out this process, a plan that will be between just her and the president, because she just wanted the president to say yes and then they'll move the people to the Supreme Court. Abra, the Chief Justice is supposed to follow the due process, because when you take out due process, everything becomes corrupt. That is why due process, normally, when you are doing things and you take out due process, whatever you do, that process becomes corrupt, because the due process will do what? Will refine the journey, will refine whatever you are trying to get. In this opposite, we go that. So I could bobo bana or sabu bana or the far processing and son I could do baby a friend way gold. You just pick a rock, it's an ore. There's nothing in there but to say way me to my tongue. You need to grind bobano or crash bobana. Now the coffee machine, na machine na yam no mana coffee to say powder. Or we are no shanke. O shanke and chasu ya and son about the now was Agya good so no say chimu and son the murder to what the murder to and son you go in the pay. It is a we ignore our process now. So gold no worth $2 million I to worth a 20 Ghana because the due process, when you skip the process, that thing does not become valuable. And that is what the Chief Justice did. She cut out the due process to benefit herself and also the president. In the end, a petitioner can't talk to us say, oh, Sir Chief Master President, mo pese Ghana for nyina hu nokure wo ma e was say omo wari Judicial Council no e was say a petition omo na say a subpoena omo e was say court show omo no omo ba committee de nimbeji tum say Chief Justice yes na say wanye sa. I think the petitioner is trying to also give the Chief Justice some room to basically clear herself. Say Judicial Council for no ye subpoena omo na omo ba court na omo be ditra ye nyina nim say u ditra under a subpoena, you know what will happen. Intimate a petitioner Mr. President. So Chief Justice said asaba ye keke nyina eboa ye betima subpoena a Judicial Council say letter we about the ben meet you omo ye da ben and correspondence lecture saying or say he's open. The Chief Justice Madam Tokonu I was say oba na obechechire nsemu. Point 21. Oh, see, obviously Kevin does Galamsey because of the way he's breaking it down. Say if you be a Galamsey boy. Point 21 said the Chief Justice's request for the appointment of the aforementioned judges to the Supreme Court was done in brazen violation of the constitutional rules for the appointment of justices of the Supreme Court, amounted to abuse of her office, and was done without fair and or reasonable criteria. Into a say 21, the Chief Justice I didn't say Makachiri Chess, Chief Justice was abusing the office. Addo need the whole woody bonny into a no chess or see a permanent unit to Akumya. Point 22, the Chief Justice requests for the appointment of the point 23. Petitioner Trobibu point 23 or say the Chief Justice, as the head of the judiciary, must understand that she has no direct role in recommending individuals for appointment or promotion to the Supreme Court. If the Chief Justice makes recommendations for the promotion or appointment to the Supreme Court, it strongly indicates either a shocking lack of understanding or utter disregard for the constitutional process and established promotion procedures. Further, the Chief Justice ought to know that she cannot have a side deal with the President to raise the minimum number of judicial or justices to the Supreme Court, sidestepping the minimum that is specified by the Constitution. Petitioner, Mr. President, the Chief Justice, say, or take a decision. No, no one can recommend nipa. No, the Bravo President said, Mr. President, Masanko for Imbra Supreme Court. Etiam Radoko. In fact, sir, Emrana Chief Justice FR so I recommend it. Nipa Edia Bro, sa obe promote yomo, sa obe di ombeba Supreme Court, sa obe momu di endibrebiano, Ghana Mrano chre, especially say Chief Justice any President Kasa say or per se or expanding the number of judges omote Supreme Court bench in this one. Abra when you use due process now it means to say the Chief Justice herself no neni daho and we bugana mraso because it's stated in the Constitution say you cannot do that. Article 128(1) clearly states it. Say you cannot by yourself behind the scenes with the president promote or nominate people without using due process. Into petition and say sign your way says a Chief Justice not to mra we boom mraso. Say Ghana your maya your person mra ye dwuma or some madam tokonu your pamono. Now ukwa your friend B arbitrary reconstitution of panels and transfer of judges. Because you say on my point o gina so edi aka the Chief Justice no yen to akonya. First one aye kind no and your friend request for appointment of 5 justices of the appeals court to the Supreme Court. And in some no wakano reason dia ba kono no. Now waba another reason tia also pam madam tokonu and that reason here arbitrary reconstitution of panels and transfer of justices. Or say Chief Justice den to me the judge phobi or no ankasa de trim onim raso now asesa judge phobi egu panel bi so watikuo bi na no ankasa mu di dwuma bi or say eno so ka ho tia or say madam tokonu ye yi ne to akonwa na mom yan kan de wa ase. 24. There have been reported incidents of Chief Justice's direct interference with duly constituted panels with no explanation or public interest reasons for so doing. We consider the reconstitution of panels to be beyond the Chief Justice's administrative power and amount to direct interference with the impartiality and independence of duly constituted judicial panels. Almost say petitioner say you may be so close to Supreme Court. Chief Justice to be change judges anyhow. Sebio or you're the Chief Justice. Now you to me the nipa miensa kotena appeals court case bi so. Ade to be chano pa no asesa omo without even going through the process. I was here. Chief Justice ade bibia hye ne nsa. Obi to be kotena case so oh ade achia ye kotena case so endu ahomachefo ne a friend say on free case so ebi wo kwa etumi the phone calls e ka chom say case no menko ho o chena obi abehya wanan o say saa nyoma ni nyina kire say Chief Justice no or abusing the office and the evidence are there. Now Uko 25 the Chief Justice's constitutional and or legal authority to constitute and reconstitute panels for the hearing of cases must be guided by the constitutional and common law principles which regulate the exercise of such power. And so is the power to transfer judges and other officials of the services. In the Chief Justice, even though ordinary Chief Justice Supreme Court of Ghana, I was say Odim Rabiso. Say about transfer of judges, and I say the judge phobia assembly so also free so, and I nipa bi so mutena case judge phobia so omutena appeals court case bi so I was say odim raso say oye Chief Justice ne nkyere say obetuma tenefie atamfo na free judge of phone so say case we free so no, it does not work like that. It has to go through a process. But Chief Justice no consistently no omo will say sa nyoma no onye otumi body sirem no agasa asime free case we so we nkodo obo a odware no pa odum say case on net so ondu court we say o Chief Justice afre say we dey wontumi tena case no obi mbra and their evidence or the aka the petition no approve say or some madam tokonu ya pamono. Now when you go to point 26, the fundamental inability to distinguish between the exercise of her administrative power and interference with the panel's judicial work confirms her incompetence quite apart from the dangers that it poses to the integrity and independence of the judiciary. Inability to understand or perform the duties of an office inadequately constitutes incompetence. Inti osi adikudientia okache president to say the two things are original so say and from Chief Justice are back where incompetence and say so but I had the lapses in her work. How she's not able to make sure say due process is followed, and also how to make sure say, administratively conducting the judicial affairs in our courts, the inconsistencies and the unprofessional attitude of her, it amount to incompetence, workflow, and judicial service, into when say Chief Justice Madam Tokono is incompetent. Sebio oni sa nyansa ho kana obetumi edi Ghana Supreme Court enim edi make sure say Supreme Court any court ehihye na se nyina no omo die dwuma amana die esi 13 into ogina sade o saka Mr. President say upon nyoma we state no sa nyoma we nyina kyerɛ Chief Justice Madam Toko no ɔyɛ incompetent dwumadi a odi no wabɛyɛ selfish wabɛyɛ arrogant wabɛyɛ somebody who has become an autocrat in a democratic dispensation. And the petitioner said, no, Mr. President, sa maami we petition we kyerɛ sɛ ɔsɛ pamono ɔsɛ yɛ yi ne to akonnwa. Point 28, the Constitution. Now, point 27. It is my contention that reconstitution of judicial panel is the ultimate way to interfere with or control the impartiality and independence of a panel's judicial work, guaranteed by Article 1272 and 1913 of the Constitution of the Republic of Ghana, 1992 Constitution. Petitioner is Mr. President. Only the Ghana Mbrakye and PFA say Chief Justice started in Sakika judge for. Any judge form to the cases so reshuffle more move without going through due process. The say might be a friend of crow ana crowjin ana fair trial. Said the dear some soko pepe yasuna obiade na koma pakofie or say the moment I obey Chief Justice or done than the judges or turn them ekasa we nkwa no ema asema sebe we say e was say no kure na ntumi nya no kure if you say ade bechimi akodi asem na yenim say judge we na atena asem we so 6 years and 6 months and 2 years na ade bechimi be court na ade chien na judgment beba na ekasa assistant judge we ye the judge we abeto so na it means say judge foforo na ye de ba no na ye bia ya man agenda bi say ombeye. Because the judge now otuna case in this one for all these years or months, no. So on one 80 case in na adentina sa judge no and to me any day incomplete case no. A typical example is the Hunyuniga case. Opuni a case no. At a point, they delay the case to make sure say Hunyuga will get to a retirement. Send a bear move to me another judge who will be dancing to the song of the Jubilee House. And there are so many cases Asia at a point Edru say a judgment tibeduno near you judge in the Obusa the Chief Justice she does not give any reason because there are some people who think say they can run the Ghana judiciary the way they want. But petitioner say sadini sia Emma pepe yo any impartiality any say idea some crojeno embaso if you say e basada na nsem na e court na say nipa bi and a sebio omo edinu amana eden akọ omo side no who is the Chief Justice attitude no sa nyoma na edeba enu nti na ogina so say yempam Madam Toko no. It's basically abuse of power. Now point 28, the Constitution is clear that no person including the President, Parliament and the Chief Justice shall interfere with judges or judicial officers or other persons exercising judicial power in the exercise of their judicial functions. That is in Article 1272. Thus, the reconstitution under the guise of exercising administrative power is a glaring abuse of her office and a fundamental misunderstanding of the boundaries of the Chief Justice's administrative authority. The abuse of her administrative power to interfere with panel's judicial functions meets the threshold of stated misbehavior. Inti enena obon the top say the Chief Justice say ya order in psychic judges we kwa ha ade be chine be ma final judgment or to free we measure ho or say sad no at the end of the day what it does is say so kokan Ghana articles no and as a constitution article 1272 no clearly say judge be ana Chief Justice sana what she is basically doing in the say she is not exercising her duties well. What she will use an argument to say what she's doing in the say yeah the juma, but in the process of doing that she's abusing her office. It say a thin line between magic and miracle. So when you're very clever you will not understand magic and miracle. Magic for a short period, miracle is everlasting. But obia weji you about say magic is miracle. That is why obetumi abuse the office no, but obeka say she's exercising her duties. But in the process, when you look at the detailing, you could see, say, she is abusing the office and what we call justice. She is not helping justice to be meted on the people. What she's doing is she's interfering in the people who are supposed to sit on cases, know the merit of the case, and pronounce legitimate judgment. She is interfering in those judgments, taking away justice from the people. The petitioner is saying, say, article in the Ghana's constitution, say Chief Justice be or boom ranoso or mere the constitution or tietia, she's abusing her office. Basically, that's what the petitioner is saying. Now, the petitioner Emma instances are a man kasa way and o state the opuni trial and I'm a kind of impona Mr. Asare Ekache Mr. Akufo Addo say examples of what Chief Justice Agya actually say or interfere in reconstitution and the panels on cases no or see that's one of the specific examples no opuni case no. Or say the ongoing case involving Mr. Opuni, the Republic versus Stephen Kwabena Opuni, Asiedu Agongo Agriculture Ghana Limited, is a glaring example of the Chief Justice's abusing his administrative powers to reconstitute a duly constituted Supreme Court panel that is seized of matter on the judicial side. In this case, Justice Hunyuga, who presided over the matter at the trial level, proceeded on retirement. Now, the trial was reassigned to Justice Kwesi Anochijima, who at that time presided over a division of the High Court in Accra before which the case was placed. The court presided over by Anochijima ruled on April 4, 2023 that the trial should start afresh, that is de novo, considering the need to observe witness demeanor and the fairness concern raised by the defense. This has also been the practice in criminal trials, in contrast to civil trials where the parties had been optioned to adopt the proceedings or start the trial de novo. This common law positions is reiterated in the Republic versus High Court, that is Criminal Division, ex parte Stephen Kwabena Opuni number, and he put in the motions and all that. Judgment delivered on 24 January 2023. Or see a typical example, a Opuni case, no. Petitioner said, Mr. President, Ubeje say Opuni case, no. Justice Hunuga, omu delay case na mani bedru ne retirement date. Justice Hunuga call retirement, no, and a Chief Justice catch the judge for your friend, no. Eye Kwesi Anochijima say onko tena case no so. Sa judge no betina case no so, and a Chief Judge catch a judge and say on restart the case no from the beginning, from de novo. Meaning, their witnesses in betina for over 5 years. Justice no study body language, study contradictions, study the inconsistencies in the defense and the criminal the prosecutor, whether their witnesses and all that, you know. Time Justice Hunyuga echo retirement and Chief Justice Kotonu ekache Justice Jima se ko. Now go to case ni so start case ni from afresh. Remember, time na Justice Hunyuga ewo case ni so no na edru baby a ewo so omyeden omuma opuni bie ni defense na opuni den eka Ghana for say this is his case. But side new judge ne ba no case dabi because remember sa case no and attorney general no witness na oye djuma okoko board page no ho court otwa atro Justice Hunyuga ka kire sa witness na wa page no ho say yes, I know say you have committed a crime. Remember, so court na say usjinsie na say o ka asema insie na wudi no kire say eni say wotwa atro in the oponi case no attorney general no witness baako edi tro o case nim ema oponi lawyers no ehu atro no ema judge gitum say atro and so Hunyuga ka say or the attorney to or sanko punish nipa no either so be jail no or say that be or train na owie case ni nyina wa be so be jail na. That is against the law. The judge was supposed to take action because the person had sworn not to lie. So in the middle of the case or proceedings, you bet say what katro e was said na the law says say I was a judge to take immediate action. But Hunyuga anye. Until after all these things, you know, Hunyuga say or call retirement or say papa we buy no. And cause papa we tina case no so and cause witness from the attorney general no. Na cause say jail no. And so papa na Chief Justice toko no den buy no say oh yen san cause start case no. Meaning the crime that the attorney general's witness committed during the trial, no, that crime will be quashed away. Next means say bonina odi and yabog bonina tugu. And no ni sa nyoma na the petition I catch Akufo Addo say. Sa nyoma way and a chese Madam Tokonu ejuma all ya odin in sa keka judge for move things around no. Nim behavior no it countermount to incompetence and also she is basically running the Supreme Court or the judicial services like her own property. Now uko another pointer omekie reconstitution of panel for the hearing of Dr. Opuni's appeal. Also Opuni case no edru point to be no omo ye appeal Manu kopie Supreme Court mokai. That was the time now. Attorney General Govt Damemo almost started say almost skirmishes. Now I say these are some of the reasons in the Chief Justice Madam Tokonu ya pamono. Now, which one is this? All right. Dr. Opuni's legal team, led by lawyer Samuel Kujo, filed an interlocutory appeal at the Supreme Court on July 7, 2023, arguing that the Court of Appeal erred in its judgment. Several months after the appeal was filed, parties appeared before Supreme Court on January 17, 2024 for a hearing. The court, presided over by Justice Mariama Owusu, along with Justice Yaudakwansari, Emmanuel Yonikulendi, George Kingsley Kumsin, and Henry A. Kofi, ordered the parties to file written submissions. Now, on May 8th, 2024, the Chief Justice controversially reconstituted the panel hearing Dr. Opuni's appeal, presiding over the new panel, which included Justice Mariama Owusu, Henrietta Mensa Bonsu, Yaudakwansari, and Ernest Gau. Only 2 of the original 5 justices remained. Lawyer Samuel Kujo objected to the new panel, citing Article 1573 of the Constitution, which stipulates that a judge or panel cannot withdraw from a case after hearing argument until judgment is delivered. Or see, the reason why Chief Justice Kosoa permanent say, open case, yeah. There was an appeal. Judges are now also appeals, so ometie and komobabetie appeal of opuni case, you know. All what happened was at the other time got case this no na Chief Justice Madam Tokonu e de onu ankasa ne tumi e judge ni bi se free so we yi ba miense free so ana mienu e na ode onu ankasa no judge fo abehiem judge ode onu beka ono ba ko ye MPP ni judge de ko Supreme Court e be hu se na MPP card bearer member gawu into see sanyoma we Madam Tokonu ye ne clearly say she has become a political judge. She is basically abusing her office by sitting behind what we call administrative duties. But you can see clearly, say, she is infiltrating. She is touching the process. She is basically abusing her office by bringing in judges. She thinks that when there's an appeal case, you know, I was said, judges in the now, some of the judges are not with cases, so they complain, they say, Mbrani clearly say, Chief Justice, you cannot take us off the case. Appeal, no? Because you can only do that after we have had the appeal and make judgment. But before that was about to happen, no, Chief Justice Madam Tokonu Kachom so move free case, no, so and overnight, no, on one of the judges me and Sabeshemu and no kahu and clearly said the Chief Justice. Embrano clearly states say Article 153 say the Chief Justice Constitution say so yes sir. Why abuse Embrano? Why they was saying you to akunya if you say unya nipa ubumra. It's a petition and say when na original so akache Akufo Addo say mami we also pamono because the Constitution states it clearly and the facts are there for everyone to see. So at this point, petitioner like Mr. President, Papa mami we she is not supposed to be the Chief Justice from tomorrow. Now, when you go further, there is another case or cite here or catch the or the petition, the Ablakwa case. Or see, the Chief Justice SI misconducting who or the Ablakwa case. Then see a then a toko new year, a then Emma a petitioner, Mr. Asari, a general Swaka, Madam Tokonu is not fit, and that the Akufo Addo should fire him. Sorry, fire her. The Ablakwa case, sorry. The Ablakwa case. On the 25th June 2024, lawyers for the Honorable Member of Parliament for North Tongu objected to a reconstituted panel of the Court of Appeal. They contended that, to the best of their knowledge, the panel to which the case was assigned are Senior Jamefe, presiding judge, Efia Sewa Saribotri, and Acha JJA. They, however, observed that the panel had been reconstituted by the substitution. They, however, observed that the panel had been reconstituted by the substitution of Jamefe and Acha JJA for Pamela Cranting presiding and Kwaku Akabwa for JS, leaving Asaribotri as the only justice of the original panel. The reconstitution panel dismissed the objection, holding that there was no evidence to suggest bias as the basis for the reconstitution. A Ablakwa case, no, at a point, Judge Fuano Motiso, na Omutie case, no. A dear Chavo case, no, nipa na omuka case omu ya be 4 no Chief Justice Madam Tokunu di onu ani to me eyi omu free case so another set of judges ebe ka case no omu ntie case no omu nim where the case started from. Chief Justice Madam Tokunu ablaka case no she committed the same crime. So it is looking like it is a behavior of the Chief Justice. She does what she wants and basically she gets away with murder. She gets away with murder every time because at the end of the day, onim say so commit a crime no cry. Nobody is going to sack her because she, from the beginning of this petition, you could see her collaboration, her behind the scenes secret letters with the president. So she's basically like an autocrat leading our Supreme Court. Now, subsequently, however, evidence emerged that Justice Jamefe was initially empaneled to preside over the matter, but was written to return the docket to Chief Justice Senior Jamefe. Subsequently, however, evidence emerged that Justice Jamefe was initially empaneled to preside over the matter, but was written to return the docket to the Chief Justice. Justice Senior Jamefe will be subpoenaed to testify in the matter. Inti omu say, or catch Akufo Addo, Mr. President, as same way Justice Jamefe is there. Say committee no who putting it together, he can be subpoenaed to come and answer. Said the American because a year Justice Senior Jamefe no, what happened and then they say a year later no, omunyina be who say the role no Chief Justice Giffrey in same and odema another judge. Chief Justice every constitutee a year the panel no, Emma at the end of the day no credible that who say Chief Justice did that by her own idea and will. Ain't subpoena. The petitioner ne kache Akufo Addo say committee no putting it together from no mun subpoena Justice Jamefe no mbeka say dia me kan me boa na say me boa otu evidence or chere facts or chere nipa also mo ba ebe chere say dia o kan nyina no no kre e say Chief Justice no ya pamo no. Now also stating another case, which is Republic versus Elisha Mahama and 2 others. Sorry, Elisha Mahama and 2 others. Into now, we're stating a cases say the Chief Justice no at the end of the day no or day obumraso or reconstitute panels. Or the Mensa judges or positions obi to meet cases so case ni ba be ready no you know the on confirm show say ni nyina no constitution is stating it clearly waka che Mr. President say what committee na Jamefe ni adede nya mo betime supini o so mo mbra said the all can no esiye anase ensi. Okay, so osade another point by ya or say when the engineer so pam Chief Justice or say usurping the functions of the rule of court committee. Now, dear now watch point 47. 7 out of 19. Mr. P, Mr. S. All right. Now, in April this year, 2024, the Chief Justice issued about 10 practice directions to regulate some aspect of practice and procedure of certain courts in Ghana. This function is by Article 157 of the Constitution reserved exclusively to the rule of the court committee. Almost say April this year, Chief Justice issue some practice direction. Sebio or the call out to say courts na Ghana no. Regulating some aspect and practice and procedures of some of the courts. Now, Article 157 of Constitution it say, and yet Chief Justice no. It is the job of the court committee. Then a Chief Justice court committee's job no. What you say Jumana solely or take a sad decision no. A sad decision and a 10 practice directive no and our directions no. It is not the job of the Chief Justice. The job of the court committee. And when you read the Constitution, Article 157 no, STT clearly say the Chief Justice is not supposed to do that. A court committee no also here. Then a Chief Justice here or say and also kaho and also Chief Justice way ya pamono. Now, say, in the exercise of such functions by the rule of court committee, the said committee is required to make the rules by constitutional instrument, but not by any other instrument. Into say sa emrana Chief Justice Esheye say sebio court ewo Ghana endi so ne ade no ewo say ade for the court committee no mo ye no mo krampo no ewo say omu di constitutional instrument so ewo say omu di emra so and enye any other emra into Chief Justice no e de emra foforo na sebio odema sa 10 directions no but practice directions no but anka wo hwema ewo say court committee na ye omu krampo no emra da ho krogin a was say omudiso edidi sa adwuma no into who say Chief Justice I decide Madam Tokonu or the Supreme Court and o breaking law anytime any day she did not care anything that catch Mr. Akufo Addo a president say Miami way sack her before the 7th of January. Now ukaiku enima the practice direction issued by the Chief Justice to regulate practice and procedures in certain matters in some of the courts were neither issued by the rule of the court committee nor by constitutional instrument as prescribed by the Constitution. In issuing the said directions, the Chief Justice usurped a function constitutionally reserved to the rules of court committee. It is technically or basically the Chief Justice abused his or her office. The Chief Justice went against the law. Article 157. That alone, no, also Chief Justice Yapamono. Chief Justice has committed a lot of crimes. And the good thing about the petition is that the petitioner pointed to the crimes she has committed. And that is the most interesting thing about this petition. The petitioner was detailed. The petitioner directed the president to facts. And the petitioner told the president, if you even need people to be subpoenaed in front of the committee to back what I am saying now, they are all alive. You have the right to subpoena them. Put everything on camera for people to see that the Chief Justice has committed a crime and she does not deserve to be the Chief Justice of Ghana. So when you read the petitioner's petition, you could see, say, he was very clear, he was very detailed, he was very direct. He made the president understand and say, this is not out of hatred, this is out of patriotism, out of correcting the judicial malpractices the Chief Justice is involved in. Into Omane Chief Justice, President Céasë say, when your time Chief Justice Nebuso. Now, when you get to point 49. I say it is important to add that the Chief Justice issued a direction at a ceremony to which several persons were invited and state resources expended to launch them. In so doing, the Chief Justice willfully caused financial loss to the state, as the said direction have no force of law. That the disregard of the Constitution's clearly laid out process for issuing practice directions fits into the pattern of the Chief Justice's utter contempt for due process, rule of law, and the Constitution that she is enjoined to protect, preserve, and defend. Now, another point I would say, Yampam Chief Justice na ebine making of administrative guidelines unconstitutionally. Now, you read the no here. Already petition now, Udu point 51 or say by Article 159 of the Constitution, the Chief Justice is empowered to make regulations for the efficient performance of the functions of the judicial services and judicial council. The constitutional provision, however, says that such regulations must be made by the Chief Justice, A, acting in accordance with the advice of the judicial council, and with the approval of the president, and by constitutional instrument. Now, further, by Article 157, the Rules of Court Committee is empowered to make rules and regulations for regulating the practices and procedures of all courts in Ghana by constitutional instrument. In May 2024, when the Chief Justice launched her practice directions, they were launched with administrative guidance. These directions were made contrary to the constitutional provisions which regulate the making of such guidelines. Those practices, directives that were related to the practice and procedures of the courts were not only to be made by constitutional instrument, but only by the Rule of Courts Committee. The failure to use a constitutional instrument shows a disdain for collaborative rulemaking and preference for running a one-person show. So too is the usurpation of the functions of the Rules of Court Committee. The Constitution and our history clearly frowns upon a judiciary that depends on the solitary decision of one person. Inti petitioner no, I'm a president at Céasë say, even the court committee no, So omo krampo no the rule of court committee no sa group no answer me take sa decision say Ghana court nyina ebia say ye pese take a decision with Ghana. Say Ghana court bia no also almost sit at 9 a.m. and at the end of the case bia also case bia end 2 p.m. The Chief Justice does not have the right to just go to a function and give that direction. No. The Chief Justice has to consult the President. The Chief Justice has to consult the Parliament. The Chief Justice has to make sure, say, and yet or no may take that sole decision. There is something we call the court, the court committee. The court committee in Ukrampono, they also have to work within some laws. They need a constitutional instrument to guide them to make those decisions. It's for the Chief Justice to solely make that decision and stand in public without consulting and making sure due process is followed. And just standing in public to say, I am giving this directive. The Chief Justice has flouted the law. It goes against Article 157. The Chief Justice knows the law, and the Chief Justice has deliberately broken the law. And that it means that the Chief Justice does not have to continue as the Chief Justice of Ghana. It was a president in the Pamono. It is looking like our Chief Justice breaks the law every 24 hours. From all that I've read, it's pointing to a Chief Justice who does not have respect for the rule of law. That is what I'm seeing. The Chief Justice does not have a respect for the rule of law because the person who appointed her does not have respect for the rule of law. The President Akufo Addo omumrano. That is why Chief Justice Madam Tokonu, per what the petitioner is saying and the evidence he's given, she is also following suit. She is not respecting the rule of law. And Intina Oka say, we have to make sure, sir, Mr. President, from what has been stated here, it was not just mere say. It was not just allegations. These are facts. Letters, meetings, dates. Into this side way, Mr. President, also Pamo Madam Tokonu. Now, Mamenko eye of Frebi grounds for removal of the Chief Justice, Article 146. Petition and Mr. President. In Jinaso way, and a me Jinaso catcher or say Chief Justice the Búrň so yam pamono or say grounds for removal of the Chief Justice. Now, before we continue with the grounds of removal of the Chief Justice, we will take a short break. After that, na ya twaso ayedeng akenkan sa diekosi.
We've always sung the first stanza of our national anthem, which asks for God's blessing on our homeland Ghana. And it enjoins us to resist oppressors' rule. Many have not taken the time to observe the second stanza of our national anthem, and the lyrics bear reflection. It says, "Hail to thy name, O Ghana. To thee we make our solemn vow, steadfast to build together a nation strong in unity, with our gifts of mind and strength of arm, whether night or day, in mist or storm, in every need, whatever the call may be, to serve thee, Ghana, now and forevermore." This stanza calls for a nation strong in unity and enjoins us with our gift of mind and strength of arm to serve our motherland, Ghana, now and forevermore.
It's exactly 6:03 p.m. U.S. East Coast time. It's definitely 11:03 p.m. in Ghana. You're still watching With All Due Respect extended version. My name is Kevin Taylor. We are breaking down the petition. We are reading through the petition. We want Ghanaians to understand. The Chief Justice and that is what we are doing here. Page by page. Na ya mo ate ase de ekoso. Adekudie I was said Chief Justice Madam Tokonu. I was said Nana Addo Akufo Addo epamono. Team, are we good? Really? Team. Semo. Let me see something here. We will. We will deal with that. We will deal with that, Mr. P. And see grounds for removal of the Chief Justice, Article 146. Now let's go to what the petitioner has written. The Constitution Or say Article 1461 of the 1992 Constitution provides that a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except for, or say Article 1461 actually our Constitution will say Chief Justice eni say pam no echire bibi say esi na nyoma na echire esi no ene na petitioner no e ka kire Akufo Addo or say 1 stated misbehavior or incompetence or on grounds of inability to perform the functions of his office arising from affirmity of body or mind. Now, Momiankai 62, as already stated, your petitioner's instant petition is grounded on the first two, which are stated misbehavior and incompetence. The two words are not defined by the Constitution. In discerning their meanings, however, recourse will be had to their literal, ordinary, and grammatical meanings. The reason for the recourse to the literal meaning of the words used in the Constitution is that the courts have repeatedly held that regard be paid first to the literal rule of the words used in a statute, unless recourse to such meaning lead to absurdity. Now, the petitioner or say, nyoma ojina so a okasa na nado danko Akufo Addo e wo se opam madam tokonu no sebio sa words na o use no obi beka say oh sa words a o use ye no Constitution enim inti adenti na words a any Constitution mu no yenjina so na yemfa pam madam tokonu o see sebio enkyere so bi nkan kyerɛ sɛ o ma me control ansa na wo mu so wodi ma me atam obi betuma ka kyerɛ so ma me control ni nyina it still goes down say we did ma me atam. Now or see, even though we use the exact words in the Constitution, no, this word, no, literally, no, you cannot just take it and say, because he did not basically go into the Constitution to pick exact words to say, Mr. President, Article 64, these words and these words are the ones I am basing my reasons on for you to sack the woman. No, does not mean, say, he does not have a case in making sure that this woman has been fired. He is saying, say, even though, no, in semina ojina so ekasa these are the grounds I am from pam madam tokonu no enye nsema particular words no unu wo air constitution does not mean say it does not reflect or it does not represent the Constitution and the parts of the Constitution he has quoted to support the words. Et say o kind Bible udru baby a friend Proverbs. So o kind Proverbs are say okay Proverbs ni keke say mebusam ana say eye Proverbs na you need to understand it in a certain way to understand what Proverbs the wom and no na petition I catch Mr. Akufo Addo say those grounds na me gina so aka say pam madam tokonu no even though words like misbehavior and incompetence might not be found in the Constitution, no, it does not mean say when you basically sit down to look at her duties and the kind of inconsistencies and misbehavior incompetence she has exhibited during her time or during her execution of her duties, no, it does not take away say the woman has committed a crime. Inti the word itself as misbehavior or incompetence, no, it does not mean say because it's not the Constitution, but I'm talking did not commit a crime. And no na oma nanado danko Akufo Addo Asiedu say. Sa words now we use to say stated misbehavior and now say incompetence no mema Nigerian say any Constitution munti madam tokonu embo krono no he's basically making the president understand. Now or see or person or share the meaning of stated misbehavior. Now or see the definition of misbehavior has evolved over time, but it typically includes into Mr. President to say sebio obika sa wona ne control ma the same person as some catch on say odidi ma amiatem enti we use it in different language but it all goes down to o ma baby or say the word misbehavior abuse of office. The word misbehavior, it can also mean abuse of office. It's using administrative powers in a manner which brings the administration of justice into disrepute. incompetence, demonstrating a lack of ability or capacity to perform judicial duties in accordance with the standards required and or expected of the office. 3, unreasonableness, or say behaving in a manner that undermines public confidence in the judiciary, such as making decisions that are irrational, arbitrary, or engaging in inappropriate relationships. 4, corruption, engaging in bribery or other forms of corruption. Moral turpitude. Moral turpitude is engaging in a conduct that is morally unacceptable, such as fraud or dishonesty. Now, Omar President Céasë say, even though he did not use the exact words in the Constitution or the part of the Constitution he quoted, the words he used, they have evolved. They also have the same meanings as what the Constitution has been stating. Nobody should hide behind grammatical errors or using words just to say because he did not use this specific word, Mahama born in our word, it at the end of the day we cannot punish her by sacking her, and that he's making people understand words they evolve. You can say words evolve, yeah. As time goes on, they start to form different meanings. They start to magnet. As they move, they start to attract and they start to change. Their meaning starts to change. And so you cannot be static or be rigid and say, because when you see some specific words in the Constitution, Madam Tokonu has not committed or flouted the laws of the Constitution or the land. It is very, very important. And into the way you abutra or you in some any brofo or use any word to much Mr. President say, it all means the same thing. The woman at the end of the day has not conducted herself well. She has misbehaved, and also she's incompetent to fill that office. Now, oko eye explanation of grounds of the petition. Oche misbehavior explanation, brazen constitutional violation. And oko down page 16. Page 16, disrepute. So what the petitioner did, and they say, Omane Akufo Addo say, the crimes the woman has committed, and he said, Obibe Jina Okache say, because me, the petitioner, I did not use some kind of words or some kind of grammar in the Constitution. It does not clearly state to say the woman has committed a crime. And in petitioner, every single statement you make, he backed it with the Constitution, and where it clearly shows to say the woman, Madam Tokonu, has committed a crime. And or make a statement to be no appointee to the Constitution. No, the catcher says statement way when you link it to the behavior of the woman at this instance, it clearly goes against the Constitution. Inti ushe petitioner. That's what I'm saying. Say, Papa no Choko petition, he took his time to detail it, because when you want to let the world know, say the Chief Justice of the Republic of Ghana is not doing the right thing, you cannot just write a piece of paper and say sack her. You need to state, you need to be factual, you need to point to what crime she has committed and what crime she has committed against the state. And the petitioner from page 1, he has been able to link every behavior of this woman, which is contrary to what the Constitution states, to let us know, say, the woman has committed a crime. So it is not about grammar. It is not about you using exact words in the Constitution. It is about you pointing out the flaws and the abuse of office by using the Constitution and parts of the Constitution to back your statement. And clearly you can see, say, the petitioner, Mr. Asare, he backed every the allegation he made with facts to prove to the president to say they are not just mere allegations. These are allegations based on facts, and the facts can be pointed out through letters and also through the Constitution, what it says. Now, sir, Uridia Kodru the part where he wants to conclude that the petitioner, in his conclusion, Mr. President, this is what he said. The Chief Justice's actions discussed herein not only breach constitutional provisions, but also constitute stated misbehavior and confirm acts of incompetence. These actions undermine judicial independence and impartiality, represent an abuse of power, and create a conflict of interest. Such actions meet the threshold of stated misbehavior and incompetence as outlined in Article 1461 and therefore constitutes grounds for removal. Also, Mr. President, in some evidence I made amount any the part of the constitution me quote their support me grounds why the Chief Justice should be sacked. You need to understand say it clearly shows that the Chief Justice has misconducted herself, she has misbehaved herself, and she has shown gross incompetence in administering her job. So the petitioner is telling the president, say, when you even take your time to look at the Article 1461, it clearly states, say, he has grounds to tell the president and Ghanaians as a whole, say, the Chief Justice basically has flouted the law, she has gone against the constitution, and it is on the grounds to say she has to be removed. Wache nyoma echere se Chief Justice no e wose pam no and wan kire ne keke otusie e no kire oyede okire otu de otu bayira no wa kire sie otu bayira no wa kire sie otu bayira o baby no kire sie nti from what he has stated no okache Mr. President say in his conclusion no the match nyina kire se Chief Justice no we bu mraso or incompetent or say misbehaving ho, and it calls for her sack as the Chief Justice of Ghana. Now call page point 113 or say the Chief Justice's role is to interpret and uphold the law, not to influence the selection process of other justices of the Supreme Court or to interfere in the operations of duly constituted panels. Or say Chief Justice Nejuma say obechire Ghana mrem Nejuma no I was say or making sure say wa church Ghana mrem na Ghana mrano wa bon ho ban. Se Chief Justice here na adwene say ordinance ebe keka judges edwuma omoye. So here na adwene say omma eye judges any judicial services no omunya adwene krogin emfa manage eye Ghana sebe judiciary na say Chief Justice no or abusing the office and answer or day or call against the Constitution of the Republic of Ghana. Or could anyone not say or could anyone say I'm trying to find where yes. Her involvement in the appointment process could unduly influence the president's decision, undermining the objectivity of the nomination process. Or see the Chief Justice here, no, it can influence the decision of the president because Chief Justice Chole Takoma president. No, guys, Mr. President, me na me the head of the judiciary. Me na me Chief Justice. Me was shortlisted people. Me was protocol list be me pesa wodi omoba Chief Supreme Court. A bit may influence the decision of the president. Ebia na inkofo na Chief Justice. The Emma president as protocol list no 5 judges no. For all you know, ebia some of them are criminals. Ebia, the Chief Justice is planning on conniving with some of them on personal basis or personal reasons to dupe the people of Ghana or to abuse their office. Until see, for the Chief Justice to even just suggest those things to the president, you know, clearly can confuse the president or can influence the decision of the president, meaning the Chief Justice, who is supposed to be the protector of the law and interpreter of the law, has now become the influencer of the law, has become the suppressor of the law. And like I said, we don't need such people or such persons to be the head of Ghana's judiciary. How could anyone not say? Here, her overreach is contemptuous of the power of the Judicial Council, which she chairs. Her involvement in the appointment process could unduly influence the president's decision, undermining the objectivity of the nomination process. Her attempt to make side deals with the president puts her in a position where the president can make reciprocal demands. Or say, per the Chief Justice aye, or throw letter. 2 letters behind the scenes without the Judicial Council knowing and conniving with the president and telling the president to do her a favor by bringing in a list she thinks is better for her. No, also the dangerous woman say a day will come the president will also ask the Chief Justice for a favor, and that will at the end of the day, undermine the justice system in this country. It means that President, yes, I favor with my Chief Justice. A day will come where the president's daughter will be standing trial. The president will pick a phone and call the Chief Justice and say, let it go. Abraham said the president's daughter has committed a crime through an ambulance deal of about $32 million. The Chief Justice will make sure the judge who sits on the panel or sits on the case will tell Ghanaians and say, Jan Kuruma is not guilty. And see, these are the reasons why it is very dangerous for the Chief Justice to be suggesting to the president and having secret meetings with the president, and then their own personal vendetta or personal reasons, to be imposed on the judiciary or on the court. Into say very dangerous. When it becomes a barter trade between the president and the Chief Justice, then it means we don't have a judicial system, we don't have a justice system, and these are the reasons why Oka said the Chief Justice must be sacked. Now, Oko Enima or say she is therefore fatally compromised. The Constitution and the established protocols dictate the process for judicial nomination, and any deviation from these procedure is unlawful. Similarly, her reconstitution of panels impairs parties' right to a fair trial and could unduly influence the panel's decision, undermining the impartiality of the adjudication process. It strikes at the core of Article 1573, which is intended to prevent any interruptions in the judicial process and ensure continuity and accountability until a final decision is made. Her reconstitution of panels is an abuse of power in violation of the constitutional benchmark for the exercise of discretion power. The Chief Justice has no administrative role once a panel is formed and cannot interfere with the judicial functions of a panel by changing members on the panel. Public confidence in the judicial system relies on the perception of fairness and impartiality. The Chief Justice's actions described would further erode this confidence, suggesting favoritism or partiality and introducing needless frictions within the judiciary. Judicial ethics requires judges to avoid actions compromising their independence or judiciary's independence. Proposing nominees could be seen as engaging in political activities, generally discouraged, if not bad for judges. Now, the all can say, Chief Justice, take a decision to interfere. Judge on better cases so. Making sure say a seminar air question or bet me judge, not the judge for Abeshaw, or bet my catcher be say, would your Koshaha, would your Ochinaman what's now so, would your by force Sanchain, or see, Sir Juma Dian and your Chief Justice Juma. Into the moment that Chief Justice Ben Addo say obey Sadiano, then it means say pay yo and answer your court no and a judiciary no. Be a friend prepare yo and answer justice no. It will never be realized. If we say Chief Justice Kosoa Sadiana, then some judges will be ruling in favor of the Chief Justice and maybe accomplices of the Chief Justice. Some of the judgments will be in favor of some people who are not supposed to get a favorable judgment. He is saying say the conduct and actions of the Chief Justice continuously reconstituting and entering panels and contradicting and forcing judges on and off their cases, which isn't her job. No? The Chief Justice is overstepping her boundaries. The Chief Justice is abusing her power. And most importantly, that confidence and belief Ghanaians a judicial system. No? The Chief Justice, through her actions, no, by influencing and infiltrating, and at the end of the day, putting her powers and imposing herself on the judges sitting on cases and reconstituted panels. No? What is going to happen? What is going to happen? And they say, GDN na Ghana for our judicial system. No, sa GDN ebe yira. Yira so a sebio Ghana for ne ho be kire. Na oba asewa na o say judicial ethics requires judges to avoid actions compromising their independence or the judiciary's independence. Proposing nominees could be seen as engaging in political activities, generally discouraged, if not bad for judges. Professor Jando warned us of the dangers of an unrestrained Chief Justice when he opined that, and I quote, "If we so unfortunate as to get for our Chief Justice a cynical, mischievous, and obstinate individual who always had the ear of the president, at least a sizable section of the judiciary could be subject to mayhem with not too remote consequences of bedlam. End of quote. The mayhem is already upon the judiciary, and the bedlam will follow unless swift actions are taken to remove the Chief Justice from office on the grounds prayed and in accordance to Article 146 of the Constitution. That's the 1992 Constitution. And the petitioner says, I therefore petition the President to initiate proceedings to remove the Chief Justice from office to uphold the Constitution, maintain the integrity of the judiciary, and restore public confidence in our judicial system. Please do not hesitate to contact me for any further information or clarification. Respectfully submitted, Professor Stephen Kwaku Asare, P.O. Box 12889, Accra North. Telephone 02635299907. Email kwakuasare@gmail.com. So that is the petition. Petition now. And the yadi akome Akufo Addo ye jina so aka se Madam Tokonu e wo se ye pamono no ene na medwudwo machiro all the evidence emu letters the secret meetings, secret letters Chief Justice Akufo Addo against the Constitution. Any basis the petitioner actually say grounds actually say e wo se mamu ye pamono, the misbehavior and also the incompetence, and the Chief Justice at the end of the day infiltrating our judicial system, imposing her will on our judicial system, and also favoring the president and his government on some political cases. The facts are there. He has pointed to the part of the Constitution that clearly states that the Chief Justice of the Republic of Ghana has to be sacked. And it is very important that we all understand to say, Nana Akufo Addo, he still has days. He needs to take action. He needs to constitute a committee. He needs to make sure the process starts. Mema obi mbedane na nonka kase Nana Akufo Addo. Nembra so ade we ama so Mahama ba ye na wabe a committee. John Mahama is not president. Akufo Addo needs to take action. So Nana Akufo Addo take action. Na John Mahama beto petition we no take action. Nobody should say a witch hunt. This is something Akufo Addo needs to do. So I believe the Chief Justice is not guilty. She has not abused her office. She is not an autocratic Chief Justice who is incompetent. Nana Akufo Addo should form a committee and make sure this is heard on camera for us to know, say, the petitioner is making a case or is not. And if the Chief Justice is clean and squeak, and the Chief Justice has not committed a crime, we all will come back and say she should go back to the Supreme Court and occupy that office. If Nana Akufo Addo fails to take action on this petition, then it means we the people will have to force the next government to take decision on this petition. And it's very important you and I understand this ABC. I'll be back to continue tonight's show. You're still watching with Audio Respect Extended Version.